Hello, everybody. Thanks for joining today's National House Campaign call. I'm Sarah Sadian. I'm the Senior Vice President of Policy and Field Organizing with the National Low Income Housing Coalition. We're going to get started in just a minute or so, and we're going to give folks time to join on. Just as a reminder, this is our National House Campaign call. We launched our House campaign to advance the anti-racist reforms and the large-scale investments that are needed to ensure that renters with the lowest incomes have access to stable, affordable homes and communities of their choice. And when we launched this campaign several years ago, we recognized that we really needed, more than ever, we needed bold policies that would help really move the needle and ensure that households with the lowest incomes and those who are most marginalized have a roof over their head. So on today's call, we have advocates from across the country. We have homeless service and shelter providers, housing advocates, resident organizers, people with lived experience, including low-income individuals receiving or in need of federal housing assistance, and many others, including philanthropy and media. So we have a really broad range of folks who are on the call, and we appreciate all of you joining in. And we have a really great agenda for us today. We're going to hear from two folks from HUD who are going to talk about a new proposed rule that would help break down barriers for people with criminal histories so that they can better access affordable housing. And we're going to hear about some really important affordable housing reform legislation that recently passed in New Jersey. And we'll learn all about how we can take some of those lessons learned and apply it to our work in our communities. Before we jump into the call, I just want to remind everybody that you can ask questions in the Q&A box. We're really going to try to get to as many of your questions as possible. It's a lot easier for us to follow your questions if you put them in the Q&A box than if you put it in the chat box, so just keep that in mind. But we do want to make sure that you're using the chat box to talk with each other, to make connections, to build relationships. And it's also important that we're treating people really respectfully, everybody who's joining on to the chat box for that conversation. After today's call, we will share a copy of the PowerPoint presentation and any of the materials that our speakers mention. We'll share that with you in the coming days so that you can review it in more detail. And with that, I'm going to turn it over to our first two speakers from HUD, Richard Cho, who is the Senior Advisor for Housing and Services, and Ethan Handelman, who's the Deputy Assistant Secretary for Multifamily Housing at HUD. Thanks so much for joining with us.
Great. Thanks so much for having us. As the slide indicates, my name is Richard Cho, and I've been on these calls before. I serve as Senior Advisor to the Secretary of HUD, and I focus on our work to address homelessness, to advance housing justice, as well as to connect housing with supportive services. I'm here today to talk about a new proposed rule that HUD published on April 10th. It is entitled Reducing Barriers to HUD-Assisted Housing. And it's currently published on the Federal Register, and it's open for public comment, and public comment closes on June 10th. This proposed rule will amend HUD's regulations with respect to how and in what ways criminal records can be used in tenancy decisions for a variety of different HUD-assisted programs, including our housing choice voucher programs, our public housing, as well as a range of different HUD multifamily housing programs. And I'm here joined by my colleague, Ethan Handelman, who's the Deputy Assistant Secretary for Multifamily Housing, which oversees all of the multifamily project-based rental assistance housing that he'll talk about in a moment. But before I get into what the specifics of this proposed rule says, I want to share a little bit about why we're doing this. A couple of years ago, when we joined the Biden administration at HUD, we were involved in a number of listening sessions that the administration had held with people who were impacted by the criminal justice system, people who had been formerly incarcerated, people who had involvement in the justice system many years ago and who have criminal records. And what we had heard was that people are continuing to face barriers to housing, and not only housing, but also to a number of HUD-assisted programs, public housing, vouchers, and multifamily housing. And we had thought that things had shifted in the field, and that a lot of the guidance that was issued under prior administrations that indicated that the overly broad use of criminal records in housing decisions could be seen as discriminatory because of the disproportionate representation of people of color and people with disabilities in the criminal justice system, that having a blanket ban on people with criminal records from housing programs constitutes sort of de facto discrimination, because you're then essentially saying, if you are basically, because how many people of color and people with disabilities are involved in the justice system, you're signaling that you are going to potentially be screening out people on the basis of race or disabilities. And so prior HUD guidance had said, landlords and HUD-assisted housing providers, you really should not use a blanket ban on criminal records to avoid violating the Fair Housing Act, and instead use an individualized approach to really look at which criminal histories are relevant to the health and safety of housing and are of legitimate interest. And also that you should take into account other factors, individualized factors that may determine that even though somebody had a criminal record in the past, it does not indicate that they will pose a risk of danger to the health, safety, and peaceful enjoyment of housing in the future. But what we'd found was, again, back in 2021, was that despite that guidance, a lot of providers of HUD-assisted housing were continuing to have policies that either kind of blanketly denied access to HUD programs on the basis of criminal records, or where were being implemented in ways that still screened out and excluded people, even when there was no particular need to do so from a standpoint of safety or even from property management considerations. For example, we had heard about people who, a person who had a 30-year-old felony conviction and has had no convictions or any involvement in the justice system in 30 years, but every time applied for public housing or voucher program would continue to get denied because that person had a 30-year-old conviction. We heard about a person who was denied for a recent misdemeanor offense that the charge was interfering with public transportation. I don't even really know what that charge indicates. I imagine they rode a subway or a public transportation without paying the fare, but that we don't believe really is relevant to the safety and peaceful enjoyment of housing. And so what we realized was that the practices were all over the place. There were many housing providers and public housing agencies that have changed their policies in recent years, but there were still a lot out there who had not, and were either overly excluding people or doing so in ways that was not fair and consistent. And so Secretary Fudge, the former Secretary of HUD, charged the department to conduct a comprehensive review to look at is our guidance and our policies and our regulations consistent and clear that criminal records should only be used in ways that helps determine when people are actually posing a risk of potential criminal activity in HUD-assisted housing, and are we being clear about that? And what that review found was that we have regulations that had not been updated in many, many years. Certainly had not been updated to reflect the more recent guidance that was issued back in 2016. And so the Secretary Fudge at the time charged HUD to amend our regulations. She authorized us to conduct a rulemaking process to ensure that our regulations were clear and consistent with respect to the ways in which criminal records can legitimately be used to, again, ensure that that housing providers of HUD-assisted housing are doing their job of keeping HUD housing safe, but also not doing so in ways that overly excludes people who simply have a criminal record. And so the proposed rule that we published on April 10th proposes a number of amendments to our regulations that would first and foremost prohibit people from being automatically denied access to HUD-assisted programs simply for having a criminal record. Instead, the proposed rule would require public housing authorities and owners of HUD multifamily housing to conduct an individualized assessment whenever looking at an applicant's criminal records. First, that means only looking at records that are recent and only certain types of records, so records that actually indicate that criminal activity actually has occurred and that are recent. And in the proposed rule, we define recent as activity that has happened within the last 3 years. We also the proposed rule will also require HUD-assisted housing providers to give applicants 15 days to provide any additional information when a conviction that is recent and relevant is flagged of concern. So if somebody has something that indicates some potential threat to health and safety that happened in the last few years, the PHA or the multifamily owner would then notify the applicant of that conviction of concern, and that applicant would then have 15 days to produce any other information that would provide a sense that there's other mitigating circumstances, such as I'm now employed, I've been working, I'm no longer involved in the justice system, I have letters of reference from my faith leader or my employer or other people who know about my behavior. I've participated in substance use treatment, and so if I had a drug-related conviction, I'm no longer that's no longer a risk that should be mitigated because I'm now in recovery. All of those other kinds of mitigating circumstances, a person can provide supporting information. And only after reviewing that additional information can a housing provider or a multifamily owner then make a determination and about whether or not to accept that tenant. The proposed rule also clarifies some existing standards with regard to when a person who has been alleged to have conducted criminal activity should be terminated from HUD-assisted housing. Our current regulations already made clear that that should only be done when health and safety is endangered and that there should be a consideration of mitigating factors. Our proposed rule simply clarifies the language and strengthens some of those existing provisions. There's a lot more in the proposed rule. I won't go into every single detail. We encourage you to read it, and we also invite you to submit public comment. We have to accept public comment through regulations.gov. That is the official way that you can provide your opinion. And our notice of proposed rulemaking indicates a number of places where we would like your input, specifically around is 3 years the right time frame? Is 15 days the right time frame to provide additional supporting information? Those are the kind of questions that we're seeking public comment on, but you can provide comment on anything else that's in the rule itself. So I'm going to just pause there, turn it over to Ethan to just talk about what this means for multifamily housing, and then I'll just share a few other things that are happening in this space as well. Ethan.
Thanks, Richard. And thanks again to the Coalition for having us here. I love coming on Coalition calls. Some of you may have seen me at the recent policy conference. I've worked with the Coalition in a number of ways and a number of roles over a long time. This rule is one I care very deeply about. It's one we've made a focus of in multifamily to make sure that we're updating the regs to reflect both the guidance that had already come out some years ago and what we know will help not just residents, but properties. We took a really practical approach in doing this to try and make sure that the participants in the program, whether they're individuals renting apartments or property owners operating and managing those apartments, see value in it. Because at the end of all of this, it should make it possible for more people to be good tenants and good neighbors as a result of these changes. And as Richard said, that the core of this is the individual assessment. It's about treating people as people rather than making a categorical exclusion. And I've heard anecdotes from property managers who said, for instance, one who told me she felt she had to deny housing to an 80-year-old potential resident because of a conviction when he was a teenager. We know she was not obligated to do that. And by changing the regulations, we should make that much clearer. We have some statutory limitations, but not a lot. And I think what you'll see in the proposed rule, which I really encourage you all to take a look at, and I know the Coalition will be taking a look at it and helping come up with some comments, hopefully as a group. But I think what you'll see is that it is aiming at something that is workable, that makes it more possible for property managers to make changes to their process and easier for applicants to navigate that process. Richard flagged the look back periods and the required ability to, if something's flagged, that you get a chance to look at it and correct it if there's an error, those sorts of things. There's really a focus on the practical here. So I hope you all will take a look at it in that spirit when you review it. It's something we know can work because we've heard from some public housing authorities and some private owners that they're already doing it. It's not everyone, and it really ought to be everyone. That's the purpose of changing the regulation. But we know it's doable. And we know from what they've told us and what we've observed that it really does make for stronger communities, ones that have more opportunity for people to achieve stable housing, and, just a fairer process overall. So really glad to do it. I see a bunch of questions in the chat. I will say we'll answer the ones we can. There are some limitations on the rulemaking process and just some limitations overall here in terms of what we can say. But know that this process is very much focused on these specific changes to the regulation. There's a bunch of other policy and funding choices that HUD and Congress overall are making, including availability of vouchers. Encourage you to also look at the president's budget for stuff there. But specific to this rulemaking, really hope everyone will take a chance to give it a read, share your thoughts with us, whatever they are, so that we can make it better. This is a real priority for multifamily. It's a real priority for HUD overall. And to give you a sense of what multifamily touches, that means the project-based rental assistance. So if there's a property where the rental assistance stays there and families move in and out. Also the Section 202 housing for the elderly and Section 811 housing for persons with disabilities. Also properties that have gone through the rental assistance demonstration to convert from public housing or another older program to Section 8. All of those are within multifamily, and those are all affected by this. So with that, I'll pass it back to Richard.
Great, thanks, Ethan. And we'll get to questions in a moment, but just wanted to add a few other things that we're doing to help remove barriers to HUD-assisted programs, as well as other housing for people who have criminal histories of involvement in the criminal legal system. One of those is that our Office of Fair Housing and Equal Opportunity have done a few things. One is that they've trained and they've provided more guidance to fair housing assistance programs and fair housing initiative programs. Those are the state and local grantees who do the frontline work of reviewing cases that may involve housing discrimination. We provided guidance and training to them on ways to determine when criminal records are being used in a discriminatory manner. Now, the rulemaking that Ethan and I just spoke about, that applies to the HUD programs. Fair housing and equal opportunities work and the work of their grantees really applies to all housing. So anybody, any housing provider would be subject to enforcement of the Fair Housing Act. And so what our Fair Housing and Equal Opportunity Office has done is ensure that the local grantees who are doing fair housing work at the state and local level are understand how to determine when criminal records are being used in a discriminatory manner, as well as instances in which things like reasonable accommodations, which is when people with disabilities can request reasonable accommodations, apply with respect to criminal records. A person, for example, who has mental health issues and now has a disability, a psychiatric disability, they can request a reasonable accommodation such that their past criminal conviction that was related to their symptoms of having mental illnesses is no longer relevant because they are now engaged in care and treatment. That's just an example, but those are the kind of things that FHEO's guidance and training has covered. They also recently adopted a final rule where they're removing a longstanding prohibition that was in place where people who serve as fair housing testers. So some of you know what a lot of fair housing agencies do is they send out people who are kind of pairs of testers who one person may represent a protected class and another person not, and they both apply for housing. And if they are treated differently by a landlord or housing provider, that is when a fair housing investigation can take place. Well, we had this rule at HUD that prohibited fair housing grantees from hiring people who have any criminal record to serve as a fair housing tester. We've now adopted a final rule that removes that prohibition. So they can now hire people who have criminal records, which then can help detect when there is housing discrimination that's related to criminal records. And then the last thing I'll mention is just some technical assistance that we're providing both through CPD and particularly in our homeless programs and our HOPWA office, as well as within our Office of Public and Indian Housing, that is providing more information to communities on how housing authorities, how homelessness programs can partner with reentry programs and criminal justice agencies to proactively help use HUD programs to meet the reentry housing needs of people who are formerly incarcerated returning to the community. So just want to share, this proposed rulemaking is part of a broader body of work we're doing to try to help provide housing. This is very much rooted in our understanding of the evidence that providing housing to people who are returning to the community from criminal justice involvement is a public safety measure. There's tons and tons of evidence that if people have stable housing, that just increases their chances of successful reentry and reduces their chances of recidivism. And also that criminal records are actually serve as a very poor predictor of whether people will be successful as tenants. And so, again, really need to look at the whole picture. People should be treated as whole people and not just based on a criminal paper record of something that happened to them in the past. So with that, Sarah, do we turn back to you, or do you want us to take any Q&A, or how should we do this?
Yeah, I'd love to ask you some questions. I have some here, and just to encourage folks to ask their questions in the Q&A box. It's easier for us to track that if you do that there. But my first question is really building off of your last point, Richard, which is, part of, I think, why landlords turn away people with criminal records is because they misunderstand or believe that that's somehow a determinant of whether or not that person's going to be a good tenant. So I'm wondering if you could share a little bit about what is the research that's out there that HUD was relying on that talks about whether or not criminal histories are a good determinant of somebody's success as a tenant.
Yeah, thank you for asking that question, Sarah. We actually have a really great piece that was written by our colleague, Calvin Johnson, who's a Deputy Assistant Secretary for Research and Evaluation. And what Dr. Johnson's work shows is that criminal records are a very poor predictor of success. In fact, most criminogenic scholars will note that like criminal records themselves are a very poor predictor of recidivism in general and whether or not people will be involved in the justice system. So relying on just a record alone will rarely give you the full picture of whether or not somebody actually poses a risk of future criminal activity. There's also zero research out there that shows that a person's criminal history will predict whether they'll be a successful tenant, somebody who pays their rent, who doesn't cause property management challenges. And so we also, though, know that criminal records are, it's not that they're not relevant at all. There are some pieces of information that are useful. And so our proposed rule preserves public housing authorities and multifamily owners' ability to look at records that are accurate, recent, and relevant. But all we are saying is that they should be looked at in the context of all the other factors, like whether a person, are they still involved in criminal activity? Are they employed? Are they engaged in the community? And therefore, relying on a criminal record alone is actually a very poor way to conduct tenant screening. I don't know, Ethan, if you want to add anything to that.
No, I thought you covered it. I've been answering a few of the questions in the chat, but I know Sarah flagged a couple to do live.
Yeah, actually, and our next question is from Thomas Knight, who's wondering, how would the proposed rule impact people who are on the sex offense registry?
Yeah, great question. So there is two specific places where federal law has been passed that excludes people just automatically from HUD-assisted housing, and that is people who are on a lifetime sex offender registry. They are prohibited from accessing HUD programs, or I should say HUD-assisted housing, so public housing, multifamily programs, and vouchers. As well as people who have been convicted of producing methamphetamines on federally assisted property, which is pretty specific and narrow conviction type. For everybody else, the proposed rule will then consider that a discretion to exclude people on the basis of what we believe are legitimate criminal records. So a person who's not on the lifetime sex offender registry, but who has a sex offense conviction would also be able to apply for HUD-assisted housing. And if their offense was not recent, it was a very long time ago, then it would not be actually considered. If it was recent, it would be considered according to this proposed rule, but also other factors would be taken into consideration, such as what they've actually been engaged in and whether there's been any history of other involvement or if they're now engaged in the community. I recently was on my travels, met an individual who had a sex offense from many years ago, but since then has built a small business. They themselves are a landlord. They own properties. They rent out to other people who are formerly incarcerated. They've been conviction-free for many years. And that's the kind of person who would very much benefit from a HUD program. But had people just denied it just on the face value of their criminal record without looking at all the other factors, that person would never have had the opportunity to have housing assistance that would have enabled them to rebuild their lives in the way that they did.
I appreciate that. And something that you mentioned was about whether or not criminal histories are an indicator about somebody's recidivism rate. And there is a comment here, or question and comment from Jennifer Mohawk, who asks, or who says, I've researched recidivism rates, and all the studies I found indicate that if recidivism is going to happen, it happens shortly after release from prison. All of this seems to, I think they're saying is that as time goes by, how a person's likelihood of recidivism goes down dramatically. Is there anything that you can speak to about that?
Yeah, I mean, that's actually, we speak to that in the preamble to the rulemaking. So we review the research on recidivism as part of this process, and it's in the proposed rule. What we found is that most the research indicates that people who have had involvement in the criminal justice system, who have a conviction, their chances of committing a crime typically happens within the first year. It drops down in the second year. By the third year, it drops down to almost zero. And so obviously that doesn't mean every single person, but most people, the research shows, after 3 years of that conviction, their chances of recidivism drops precipitously, such that we believe that any convictions that are older than 3 years is presumptively unreasonable, that that there should be no look back period at a criminal record longer than 3 years, according to this proposed rule. Again, seeking public comment on that perspective, but that is what our review of the research indicates. So I really appreciate that question and comment in the chat.
And I'll add, this is why the proposed rule focuses on individualized assessments, because we know that statistics are useful, but they don't tell us everything, and that people are people. And that's why we proposed that approach in the rule.
I love that factoid too. I didn't realize that about the likelihood going closer to zero at year 3. I feel like if more landlords knew about that, that could also help open the doors. So I'll ask one more question. I know you have a lot on your plate, so we'll let you go after that. But there are other states that are out there that have put in place protections for people with criminal histories, and I'm wondering, how would this impact residents in states or localities that have those protections already for people with criminal histories?
Yes, we actually reviewed that, and we speak to that in the NPRM itself. We talk about places like Cook County and New Jersey that have passed laws that have, and we certainly looked at the structure of those laws in taking this account. We also know of policies, New York State, for example, for housing subsidized by low-income housing tax credits. New York State has a policy that they also have to require an individualized assessment and limits to look-back periods for people with criminal records. So a lot of that was part of our review in determining how we wanted to pursue this rulemaking. What I'll say that is, when states and localities pass laws that provide housing protections for people who have criminal records, there's often this legal question about whether federally assisted housing programs are covered by state and local law. There's sort of gray areas in terms of how is that reconciled when you have a federally assisted program in a jurisdiction that has passed some of these protections. I think our rulemaking, if and when we get to the final stage of this rulemaking, would then enable there to be greater reconciliation between laws such as exist in Cook County and in New Jersey, and HUD-assisted programs that operate in those two jurisdictions and others.
Well, I want to thank you guys so much for joining with us. Clearly this is incredibly important work. We all know about the enormous barriers that people with criminal histories are faced when they're looking for housing. And this is a really important step forward, and also a really important opportunity for folks on this call to weigh in with HUD, to give feedback to the proposed rule, to help you shape it as it goes forward. And I just really appreciate your work on this call, but also more generally with HUD. Thanks for joining.
Thanks for having us. Really appreciate it.
Absolutely. And before we move on to our next speaker, I did want to ask Kim Johnson, who's our policy manager with the National Low-Income Housing Coalition, to talk a little bit about those opportunities for folks on this call to respond to HUD's proposed rule, and hopefully to submit a comment in favor of reducing barriers for people with criminal histories. So Kim, I'll turn it over to you.
Thanks so much, Sarah, and hi, everyone. I'm Kim Johnson, the policy manager here at NLIHC. It's my pleasure to be here with you today. I also lead NLIHC's work related to reentry housing and decreasing barriers to assisted housing for people with conviction and arrest histories. And so this is a very, very exciting opportunity for all of us to weigh in with HUD and help shape this final rulemaking. We have a resource page available on NLIHC's website that I believe my colleague Elena is going to be dropping in the chat. Thanks, Elena. And so that link has information about HUD's NPRM, including a very, links to easy top line overviews of what is in that 150, I think, page rule. And it also has resources to help people, and we are especially asking people with lived experience, people who have had to navigate the criminal legal system after leaving it, and who have experienced what it is to have to find housing with a conviction history, to weigh in and share their stories with HUD. Your perspectives are so important and so needed in ensuring that we get this final rule exactly right, or as close to exactly right as we can within the limitations of certain statutory restrictions. But it is a very, very exciting opportunity for us to weigh in and help shape policy making. A lot of people think of legislation as the only way to shape federal policy, but I cannot emphasize enough that comments and notice of proposed rulemaking are another really excellent way of making your voice heard. And so please do feel free to reach out to me, to Richard and Ethan as well with questions. And we look forward to working together to get this final rule out. And I'll turn it right back on over to Sarah.
Okay, stay on the line though, Kim, because I want to ask you a question. If I did see, for example, there was a question from Rachel Johnson that we weren't able to get to with our HUD folks about enforcement. If that's something that Rachel wants to weigh in with HUD about for this proposed rule, how would she go about doing that? And my second question to that is, for people who might not feel like maybe they've never submitted a comment before, maybe they feel like they're not experts when it comes to this specific issue. What advice do you have for them about how they can still engage and the importance of them doing that?
Yeah, definitely. So can you repeat the first part of the question? Sorry.
Yeah, so one of our guests, Rachel, mentioned that enforcement would be a really important element of this. So I wanted to use that as an example of how could Rachel be weighing in with HUD through the comment process to talk about the need for enforcement.
Definitely. And so to Rachel's question as well, enforcement is a really foundational piece of, any piece of regulation or law, because as good as a regulation or legislation is, if it's not enforced, then what good is it? And so, yes, I would strongly encourage folks to weigh in with HUD on that aspect of the rule to make sure that there are mechanisms in place to ensure that landlords are held accountable to these new standards, and to ensure that people who are applying who feel that their rights have been violated have a mechanism to report that. And so when it comes to leaving a comment, so the link that is on the screen now and that my colleague Elena just dropped has a lot of resources, including background information and questions that people should consider when they're leaving their response, particularly for people with lived experience. Questions like, what was the process like for you when you were leaving incarceration? How many apartments did you apply to? What was that like? What impact did that have on your ability to find a job or connect back to community? Relying on those kind of lived experiences are so important. For advocates who work with people who have been directly impacted, you can write to or write about your experiences with working with directly impacted people, the challenges that they've faced, what you've seen them go through, and of course, your suggestions for how this process can work better for the people that it is trying to serve.
And then my last question, in case folks in the audience haven't gotten this, it's incredibly important for them to be weighing in with HUD, but in part it's because we might be hearing from landlords or housing providers who don't want to break down barriers for people with criminal records. And I expect we will hear from many landlords who might weigh in with HUD sort of opposing this important step forward. So maybe Kim, you can share sort of some of the strategy about why it's helpful for people to weigh in and how that counteracts some of the messages that HUD might be getting from people who take an opposing point of view.
Yeah, definitely. And to kind of drive a point home, I'm going to lean on an anecdote from a meeting I had on the Hill with Hill staff, where they were talking about HUD's 30-day eviction notice for HUD housing, and how they were hearing from housing providers and landlords about how disruptive that 30-day notice was and all of that. And so, but they weren't hearing from, the people about the importance of that rule. And I said, well, yeah, the people who are impacted by that rule are trying not to get evicted, right? And so this is one of those opportunities where it's really, really important for the people, again, who are navigating these systems, who know what it is to be somebody who is released from incarceration, to not have housing, to make sure that their voices are heard as well. Like you said, Sarah, unfortunately, I do think that we can anticipate a certain amount of pushback from some housing providers who might be very reluctant to provide that full chance at fair housing for somebody. And that only makes our work more important to make sure that our voices are heard and taken into consideration over and above the kind of voices that might be heard weighing in a negative way.
Yeah, I so appreciate you jumping on to answer those questions, Kim. Folks will be hearing from us in our newsletter that goes out every Monday. Also, as a follow-up to this, we'll share information, including this link, so that you can take action and submit your comment. And thank you to Kim for helping to put together all those resources with our partners. Okay, we're going to move on now to our next speaker, who is Stacy Berger and Matt Hirsch from the Housing and Community Development Network of New Jersey, about a big win that they had in their state. Thanks for joining, Stacy.
Thanks, Sarah. Thanks for having me. Can everybody hear me okay? Great.
Hear you great.
It's actually great. Thanks. It's actually just going to be me because we are dividing and conquering. You might be able to see my sticker here that says Protect Oprah, which is not the TV star or multimedia star, but our Open Public Records Act here in New Jersey, which we use as housing advocates and development experts to identify places where in local and state agencies and local government, to see what they're doing. It's like a local version of FOIA, and it's on the chopping block today after 23 years of being pretty effective. So we are dividing and conquering, and Matt is trying to wrangle up some last few remaining no votes, which is the last time I was here at the State House, which is where I am. I'm hiding out in the basement of the New Jersey Legislative state capitol. I wanted to talk a little bit to folks about the Fair Housing Bill that we passed it started last December, and we were able to get it passed and signed in the first quarter. In fact, it was signed during the NLHC Policy Summit, so we weren't policy forum, so we weren't able to attend the forum because we weren't able to attend the bill signing because we were at the forum. So in New Jersey, we have a constitutional requirement that prevents communities from engaging in exclusionary zoning. And if you've been following any of the housing work here in the Garden State, you would know that's called the Mount Laurel Doctrine. It's a series of court cases that have been in effect for 40 plus years. And it comes out of a case litigated by the NAACP of Mount Laurel all the way to the New Jersey State Supreme Court. Multiple lawsuits have ensued over 4 decades that affirmed the right of residents to be able to afford to live in the communities that they choose to. So it requires that communities plan and approve and in some cases appropriate funding if needed to allow developers to build affordable homes for people who wish to live in those communities. And it comes out of a back and forth between the former township mayor of Mount Laurel and an activist, Ethel Lawrence, who lived in Mount Laurel and wanted to live there and had put in with the NAACP and her local church for a zoning application to get a waiver to build garden apartments for herself and her neighbors. And she was told by the mayor at the time that if folks couldn't afford to live in Mount Laurel, they should just move somewhere else, because the town was not obligated to provide zoning of any other kind than the kind they chose, and the kind they wanted to build was single family, 1 acre homes at the time, which is what a lot of New Jersey has, but in a lot of places now. And as a direct result of the Mount Laurel decisions, we have been able to force communities that wish to be exclusive to comply with the law and the legal precedent. And so for the last 15 years, there has been an administrative process that has been supported by the courts and undermined by the prior gubernatorial administration. Governor Christie made a top priority of his to gut what was then called the Council on Affordable Housing. And that regulatory agency was responsible for assigning a number and a methodology to each community that was subject to the Mount Laurel decisions. Because there's some naturally occurring affordable homes in the marketplace in some of our more urban communities and some of our rural communities. Not every town in New Jersey has a housing obligation, but over 350 of them do. And for a long time, that was just chugging along, and that process went through. Every 10 years, the towns and the state would get together and decide what the methodology would be and how many homes each town had an obligation to provide zoning for. The towns don't have to build them themselves, and they don't have to pay for them, but they can't exclude them either. And if they did exclude them, they would be subject to what's called here a builder's remedy lawsuit. So if the town did not provide appropriate zoning choices, a developer could come in and sue. And the way they got around the suing part was to do these plans, and the plans would then be in effect for 10 years. So we had 2 rounds of 10-year plans. First 2 rounds, they went along pretty okay. In the third round, in about 2005, and I'm summarizing here because we don't have 3 hours, and it's a lot of history. But in about 2005, the state changed the methodology, and then in 2008, we were able to get, along with our partners at Fair Share Housing Center and lots and lots and lots of other allies, we were able to get the state to outlaw a portion of the planning process, which was called, and these are terrible acronyms, the regional contribution agreements. And what that did was allow towns that had an obligation to pay towns that didn't to take 50% of their affordable housing obligation. So if you were a white, wealthy, exclusive, and rich suburban community, and you did not wish to do all 500 units, you could pay a very nominal fee to a generally urban community for pennies on the dollar to take 250 of your housing unit obligations. So when we got that outlawed in 2008, multiple municipalities went absolutely bananas and really made it a campaign issue for the next governor to gut the Council on Affordable Housing, which enforced this planning process. And that happened under Governor Christie. And then everybody went to court because we're in New Jersey, and so that's what we did. We went to court along with Fair Share Housing Center and the Supportive Housing Alliance and many, many, many other organizations. And we got the governor's, at the time, Governor Christie's executive order overturned. And this process has been happening in the courts, through the courts for the last 9 years. But we're almost at the end of that, essentially the 4th round of this process. And so a lot of the housing advocates, and led by our friends and allies at the Fair Share Housing Center, started to work on a process that would both codify a good methodology and protect the municipalities from the builder's remedy, provided they were meeting those goals. And so the last 5 months have been really centered around how to make this legislation work. And there was a lot of advocacy, a lot of which we learned from and leaned into the work that NLHC does in terms of messaging and really, making sure we had the data. We used a ton of out of reach information, and the gap report was extremely timely because it really showed that we need to build these kinds of homes, multifamily and rental for folks who just simply are left out of the market. And so we've been advocating for the legislation in a number of ways. There were some pieces that were not originally fantastic. It does not explicitly include a set aside for inclusionary zoning, for example, and originally had a much larger share of transitional housing that didn't really match with our agenda to support, protect, and expand housing first choices. So we had some work to do there, and we were able to meet with numerous sponsors. We held multiple legislative visits. We had weekly and sometimes daily action calls over the course of the holidays, as well as in the beginning of the new year, we had six legislative hearings on the bill, 2 sets in each house, and then frankly, a very close final vote. And so the bill is actually being implemented now. It's about to take effect for the next round, which would start in 2025. And it's based on census data and available land and the kinds of jobs that are being brought to a community. And that methodology is really what was established by the court system in 2018 by Judge Mary Jacobson. So we call it the Jacobson methodology. But it really takes a holistic approach at what a community is going to be expected to do for a decade. And it gives those communities the ability to build and to design and approve and build a variety of housing choices. So it could be some high density and multifamily housing. It could be some garden apartments. It could be some home ownership. It could be a range of those things. They really try to leave it up to the community to decide for itself what kind of housing they want, as long as they're meeting that number. Now, there are some communities that have already said they are not going to participate, and they are going to be sued. So we've started to see a few of those lawsuits start to percolate, including in northern New Jersey, in Milburn and Livingston, and some of the other more very exclusive, wealthy white towns. And so some of it is messaging for our members to make sure that they're working with the nonprofits are working with the local governments in those areas to understand what affordable housing is and also what it isn't. Because as we, I think, all know on this Zoom and in the work that we do, that there's a lot of stigma and negative messaging around who needs affordable housing and who gets it. And we heard last year at the policy forum, Matt Desmond talk about sections of his book, Poverty by America, talking about some of those NIMBY experiences that he witnessed during some planning and zoning board meetings. And we really have tried to counter that by organizing our members to bring their supporters and their donors and their clients and the folks who support what a Habitat for Humanity is going to do, or what a supportive housing association organization is going to do, or what some of our local community organizations are looking to build that popular support, and not take for granted that the people who are elected to represent their constituents are going to understand that affordable housing is something that everybody needs. So it's been a very long road to get to this point. It's been the entirety of my time at the Housing and Community Development Network of New Jersey, as we have functioned without a formal process up until the Jacobson ruling in 2018. And since then, we have built tens of thousands of units, and we expect that the next decade is really going to make a dent in what we saw from the GAP report, which shows that New Jersey needs about 225,000 extremely low income homes. And so we know that we're not going to get them all through the Mount Laurel process or through this new process, which has even a different name that I don't even remember anymore because it's been such a long time today. But we all call it the Mount Laurel process. So there will be tens of thousands, if not 100,000 homes built in all likelihood under this system in the next decade. And those are going to be deed restricted for quite a while. The LIHTC developments and other multifamily units are going to be deed restricted for, I believe we left it at 20 years. And then the home ownership units are going to be 30-year deed restricted. So they will stay in the market and stay protected for a really long time. And that's the most important thing, I think, when we come out of this, is that we are protecting and preserving affordable homes so that we are not constantly in this rat race of having to build new ones and lose units on the back end. And I think New Jersey has a lot that we can do to be better about preserving what we have. So I will end there and take questions.
Yeah, it's just such an amazing victory for you and your partners. I'm so excited for you, especially I didn't realize just how long that effort was. It's really remarkable that you guys were able to get this done. And I'm wondering, you sort of talked a little bit about this, but if you could just share a little bit more about what sort of opposition did you face to this and how did you overcome that?
Yeah, I think part of why I'm here today about the Open Public Records Act, which is a perennial thing that our League of Municipalities, which is our mayoral and local official legislative lobbying group, which I would say does not speak for all mayors and elected officials, but certainly acts like they do. They were the prime folks in opposition. We had numerous mayors and council members from either rural places that don't have sewer hookup or don't want to pay for sewer hookup, and some suburban, exclusive suburban communities who didn't want the legislature to change the character of their community. And like it's not subtle, right? It is exactly what it sounds and looks like. It is, it is racism and it is exclusionary zoning and segregation. New Jersey is one of the most diverse states in the country. We're also one of the most segregated places in America. So we have this very diverse overall population, but when you could drive from town to town, we have 565 municipalities and only 10 million people. So, it's not, we had a lot of mayors who were opposed to this legislation, and we overcame it by organizing them and getting their constituents to call their legislators and kind of leapfrog over the local elected officials who, in some cases, just either didn't understand the law, didn't understand that this was not really, this is 40, 45 years of, legal precedent in New Jersey. And although we have seen in every possible iteration of every level of government that just because you've had a right doesn't mean that you get to keep it, and that we need to be vigilant on those things. One of the things that I think we are seeing today is that the legislature did that because they believed in it, and then they also felt like they had to give something back to the mayors. And so we are paying the price for that, I think, in the exchange of the Open Public Records Act, which is not something I had anticipated, to be really honest. And it's very disheartening to do that, because we can't really do our work, right? Like, we can't do our work unless we can access public records. We can't see what public safety and crime statistics are like in places where there's spikes in homelessness, or we can't see what the zoning boards are doing in some places unless we file an Open Public Records Act request. So it's going to make it harder for people to do the development that the legislature just said they wanted people to do. So.
Yeah, ongoing. So one step forward, another step back, more work to be done, but just
story of our lives.
Definitely. I applaud you. Thank you so much for joining on. We appreciate you sharing this. I hope other folks can take some of the lessons from this and think about how they can move similar success at their state and local level.
So Sarah, just on that note, we've been in touch with a couple of our colleagues that we saw at the forum about how they could potentially implement something like this. And there was a great article that Adam Gordon, who's the executive director at Fair Share and one of our closest partners, wrote over the weekend. I'll send it to you, and if you can share it with folks, that would be great, because I think it really is a roadmap for how other places can look at what we've done, and we've done a lot. It's not that it's we're not done yet, but we're headed in the right direction here. So it would be great to have other states take that model on.
Yeah, that's awesome. We're happy to share that. Thanks,
great.
Stacey.
Thank you all so much for everything you do and the opportunity to be with you all today.
Appreciate it. And now we'll move on to our final speaker. I'm going to welcome back Kim Johnson, who's our policy manager, to share an update about what is happening in Congress right now and how folks can take action. Thanks, Kim.
Thanks again, Sarah, and hi again, everybody. I'm still Kim Johnson, still the policy manager, still at NLIHC, but this time I'm here to talk to you about what's going on Capitol Hill. So we got word last week that House Appropriations Chair Tom Cole is planning on releasing to the Appropriations Subcommittees their top line allocations, aka the 302B levels. For a little bit of background, 302Bs refer to the top line number each of the 12 appropriations bills will be able to spend in the coming fiscal year. So we are expecting the House to receive those top lines as soon as this week. Chairman Cole sent out a very ambitious schedule to get all of the House's appropriations work done before the August recess, I believe. Yes, before the August recess. Even with this ambitious timeline, nobody is really expecting a final bill before the elections in November. A lot of the action around appropriations is going to have to wait until after that. And so it's really difficult to know the path forward and what we're dealing with. Of course, we're still dealing with appropriations levels that are predetermined by the Fiscal Responsibility Act. We're operating under a 1% increase from the previous fiscal year. That is insufficient, as I'm sure everybody on this call knows, to keep up with the increased cost of HUD programs, which also have to rise along with inflation in order to maintain the number of households that are being served. And so our work ahead of us is going to be ensuring that HUD's programs, and especially the tenant-based rental assistance or housing choice voucher program, receives sufficient funding to renew all existing housing voucher contracts. And we are pushing for an expansion of the program to an additional 20,000 households, which is a significant number, but still a drop in the bucket compared to the level of need. We're also pushing for expanded assistance for homeless assistance grants, asking for full funding for public housing operations and capital repairs, and increased funding for the Indian Development Block Grant in order to address the housing needs of people living on tribal lands. Finally, we are asking Congress to maintain funding for the Eviction Protection Grant Program, which is a really vital program that helps communities set up right to counsel programs for people facing eviction. All of that is to say we are going to keep on pushing. We're going to keep on weighing in with our members of Congress on the importance of increasing the funding for these programs in the coming fiscal year, and pushing for hopefully a side deal that will allow for an increase above the caps that have been stipulated by the Fiscal Responsibility Act. So that's where things are with appropriations. One other side note I'll make too, is that Chairman Cole in the House has issued a rule that does not allow nonprofits to apply for earmarked funding. And so that would impact nonprofits across the board. Fundamentally, though, it is in response to a lot of the culture wars nonsense that we've seen crop up around funding for programs that serve LGBTQ community members. So because you can't say specifically, we will not fund programs serving LGBTQ people, Chairman Cole has instead issued the blanket statement of no nonprofits can receive earmark funding in this fiscal year. The Senate, however, still does allow earmarks in their bill, so just setting up another fight over a final funding level for FY25. And so finally, because I know that this matters a lot to a lot of our colleagues and our network, to speak on the tax bill that was passed by the House, and for a quick recap, that tax bill would provide an extension of the child tax credit and an expansion of certain low-income housing tax credit provisions in exchange for extending some corporate tax breaks that were slated to expire next year. Unfortunately, while that bill passed the House with bipartisan flying colors, it is now held up in the Senate. Senator Crapo of, I believe, Idaho is the ranking member of the committee in charge of tax legislation, and he is holding it up largely to, as has been quoted, not give Democrats a win in the coming year. And so it is being held up for largely political reasons. There's hope among Republicans that it will, die quietly behind closed doors, while Senate Democrats are trying to at least bring the bill to the floor for a vote to make public their members vote on that final bill. So that's where things are. I will turn it back on over to Sarah to finalize the call and take us out.
Sure. One more question though from Cassandra Jackson, who's wondering, what do you mean by earmarks? What is an earmark?
Yeah, great question. So an earmark is basically reserved funding for a specific community development project. If you look at the federal budget, they are included under a broader program called Community Development Block Grants. But basically, earmarks are members of Congress, their constituents will write to them and say, hey, we want funding for, say, setting up a specific program to serve people experiencing homelessness. The member of Congress will then take that into consideration, put in a request for funding for that specific program. Generally speaking, members get the earmarked request that they like or that they want. This is really kind of the first time that we've really seen members of Congress try to cut out their colleagues' earmark requests. And again, it really just goes back to a lot of the kind of culture wars nonsense that we see permeating a lot of policy these days.
Tell me about it. Thanks, Kim. I don't see any other questions for you in the Q&A box, but appreciate you joining on and giving us an update about where things are and how folks can be continuing to do the hard work of encouraging members of Congress to fund the programs that we care so deeply about. Thanks for joining. Okay, and with that, we're going to close out our National House call. Thank you so much for joining with us. We really appreciate your engagement, your input, your conversation in the chat box. We use that often to see what's of interest to you, what future topics should we focus on. So I just want to thank you guys so much for being with us, and we'll look forward to seeing you next time. Appreciate it.